Okay, welcome back, folks. We are now switching gears and we are going to be taking some testimony on H92, which is an act relating to Human Services Board fair hearing proceedings. First up, we have Brenda Siegel, the Executive Director of End Homelessness Vermont. And Brenda, join us at the table, please. So as you might recall, if you have taken a look at the annual report of the Human Services Board, one of the areas that they have seen an increase in is appeals relating to general assistance housing. And so wanted to get some sense of people's experience with that. And Brenda has assisted individuals in that process. And so welcome to our committee this afternoon. We appreciate that.
Thank you.
And you know all of us, so the floor is all yours.
Okay. Good afternoon. For the record, I'm Brenda Siegel, the Executive Director of End Homelessness Vermont. You all are already aware of what we do at End Homelessness Vermont, and just so you're aware, and I think you are, our clients are having a pretty rough day today due to mass exits across the state and technical challenges for people who do qualify under the executive order. So this testimony will go through our experience, some examples of how fair hearings work, and I'm able to answer a lot of process-related questions, but it's not as prepared, but I'm a wealth of knowledge, so feel free to ask me questions. Just as a reminder, End Homelessness Vermont, as Chair Wood said, while we support people through emergencies and help people experiencing homelessness, and people with complex needs and disabilities on an ongoing basis, we also help people who are and who are not our clients on through fair hearing processes. When legal aid can't take them on, or when they prefer to have an advocate as to an attorney with them. As part of my job at Homelessness Vermont, I read and learn all the related rules, regulations, and relevant laws related to disability. I shouldn't say all, most. Related to disability, emergency housing, and regular housing and other issues. But my areas of expertise are mostly around housing, emergency housing, and disability. And that's where I usually am in a fair hearing, is around emergency housing. In my time in this role, I've represented many people as an advocate in many fair hearings. But I feel it's important to say that we try very hard to resolve before we request a fair hearing, so even before the request is made. This level of communication has been effective in making sure that people with complex needs have the right documentation, information, and identify a problem when there's a problem at a hotel that's the result of a disability.
Brenda, so in doing that, in trying to resolve an issue before it even gets to a request for a fair hearing, who is it that you deal with? I mean, are you dealing at the local level? Are you dealing at the state level? Are you know?
That's next. That's next.
Oh. All right. Well,
one thing that I didn't talk about before when I testified was that End Homelessness Vermont, though I think my staff Shelby did talk about, does work on a special project with economic services with specific workers. And where we are specifically working with people in emergency situations who have complex needs or ongoing, who have complex needs and extreme disabilities. While you'll hear a lot of things that I think would help make fair hearings go a lot more smoothly today and better experiences for our clients, both related to the process departments and reactions to the process, I just want to name that this partnership that supports people with complex needs has prevented a lot of fair hearings for clients. So you did hear him say that some have gone down. We used to have so many of these, but because we're able to work through a lot of them and make sure people have the right documentation and talk through their disability needs, that has really prevented a lot of them. And that is due to this partnership that we have.
and does that require you to be in contact with people like at the commissioner's office, the deputy commissioner's office, or are you able to resolve those things, like with the local ECF office?
Sometimes that we're able to resolve them at the local economic services office. Sometimes we're able to resolve them with the economic services workers we work with, like often we are. And then sometimes I have to email or call or have a meeting with the commissioner or other people in leadership. to work through something that I think is that where there's an incorrect rule. We try really hard not to put too much pressure on the economic service workers we work with. So as soon as the conflict is something that's really a management conflict, we then just write to management instead of to them, so that they aren't put in the middle of that, because the relationship we have with them is really, really important to us resolving these things. And sometimes when it's related to someone's disability or not their disability, the effective, I just wanted to name that because the program should be celebrated. It's a really, really great program. It's making a big difference to reducing those hearings. And so I wish that more people knew that they could have access to this. It's just very good.
I'm confused. Access to what?
Access to being, like, I wish that there was a way to refer, not to us only, but that there was a way so that people with complex needs and disabilities, before they get to that point, with people who really do understand the rules, could actually have these conversations a lot more than they do right now. Because I do think those fair hearings elevate very quickly, because they're the next question that's asked, which is so that they have that right. But they don't the client on the other end doesn't necessarily know that there are people they can reach out to work through whether or not a fair hearing is the best option for them. And so we do sometimes talk people. There's a couple of different ways that we handle it. Sometimes we talk people out of having a fair hearing, not because we're trying to say they shouldn't have that right, but we know that it's going to fail. And we want them to know that. We say we will sit there and we will represent you if this is what you want to do for your rights, but we want you to know that it probably won't work. And is it something that you'd really like to do? Or should we work on other things? And that's not something that everyone has the opportunity to do, and to still have someone say, but we will be there and represent you if you need. And that's unique, because if you're with legal aid, if they think it's going to fail, they probably will not take that case. And that's because they're attorneys and not advocates. If it's a different role. It's also such a wonderful thing that people can choose a friend or family member or an advocate to represent them, as opposed to in court. But it would be good if they knew who to turn to. That's what I was sort of saying. Because if they don't have it, people experiencing homelessness often don't have that person. And so there are, and the people who, like, in organizations, there's not always someone who's someone who's really a rules expert and can understand the process to represent them either. So those are things that would be good. That was one. I bolded my recommendations because I didn't think I'd be able to get through this clearly. So first, I will tell you a little bit about the process of requesting a fair hearing, because I know that came up with Judge Reinhardt, Hearing Officer Reinhardt. An individual or authorized representative can request a fair hearing. In the emergency housing, if the fair hearing is usually expedited, as you heard. If the individual has an attorney representing him, then the assistant attorney general will communicate directly with the attorney. If the person is representing themselves, then often the department speaks with them, which in my opinion is a little bit of a conflict, because before they get information and the client doesn't always know that it may not be in their best interest. And so they don't get there's a challenge there. That would be a place where I think it would be really good if there was a requirement to have somebody who's impartial, or at least the person to know when Economic Services calls them or the department calls them.
Go ahead, Representative Bishop.
Can you help me understand those circumstances where it would be disadvantageous to go ahead and move through the fair hearing process?
Yeah. So for example, I'm going to get into this a little bit, but for example, the 80-day rule last year, there's a huge uptick in fair hearings after that. And especially people with disabilities. Some of the department communications confuse people, especially people with traumatic brain injuries or schizophrenia, people with very significant mental illness, where they thought that they would qualify because they had a disability. And so also the fair hearing process will be really stressful on them. And they were going to have to be outside because there was no other choice for them. And so it was really important to us that they understand that it probably would fail, and that where they want to spend their time, and that the process looks like an AAG is going to be questioning them. The AAGs were a little more tame during that time because they did understand that people just didn't understand.
So it might not have been,
Tame is not the right word.
might not have been that there was a better avenue or even a certainty of finding another way of getting a better result. But I think as you framed it, sort of level setting for them, their expectations and where they would be spending their energy, time, et cetera.
Right, but also in the other instances we're talking about where we talk before they ask for a fair hearing, it's much more, it's a much quicker process for someone to resolve it with the department before they go to a fair hearing. So let's say they're going to be exited today, and the real problem is that we don't have their eviction paperwork, so they would qualify for no cause eviction. Well, they may not know how to access that paperwork, but we do know how to access that paperwork, and so we can get it fairly quickly. So that was just one example of what can happen.
Paul, did you have a question? No, okay.
Thanks. So same thing. If an advocate is representing the person, there's a bit of a gray area, and sometimes the clients specifically ask to communicate through us, and that is not always respected. And so one of the recommendations that we would have is that there be a rule that if someone is representing them and unless the client has specified that the first communication should be through the person representing them, if the department is aware.
So you said a few minutes ago that the person can elect to have a representative with them.
Right.
Or, does that also apply to the fact that can a representative initiate the fair hearing or the appeal on behalf of an individual, or does it need to be the individual themselves?
That can only happen if they're an authorized representative. So in other words, the person has already signed a document that says that this person can speak for them, can make decisions for them, can do their voucher, can do their application, and can decide yes or no on things, which we often are for clients with very complex needs.
Okay, and is that a piece of documentation that is provided by DCF?
The authorized representative form?
Yes.
Yes.
Okay.
Yes. And we have requested in the past that when one of our, I totally forgot to write this, but when one of our clients does request a fair hearing and they see the authorized representative form, that we also be notified, which we have a legal right, because this form is signed, to know information about the client, and they have declined to notify us. And so we would like that. We understand that maybe there could be, if you request like a check form on the authorized representative form that says, if you request a fair hearing, I would like this person to be notified. Because we understand that there's people who sometimes have a provider at a shelter, for example, who does call for or with them, but they might not want them to be notified if they ask for a fair hearing. So I think that could be a checkbox, and then that could be an automatic thing that happened. And that would have, in many cases, that would allow us to work through it ahead of the fair hearing. And that's why we want to know, because we feel like sometimes our clients go through it who, for example, have dementia, and they really cannot remember the details, and we may have all the details.
Mm-hmm. And so I want to make sure that I'm understanding what you're saying is that you would like better recognition by the Human Services Board of the authorized representative and the ability to receive notifications, the ability to be there on behalf of an individual. And it sounds like it's not necessarily formalized so they enable it sometimes and sometimes they don't, it sounds like.
Yeah, right. So if I write to the Assistant Attorney General and say, I'll be representing this person in this case, then usually right away, if there's already an authorized rep form, they say, okay. But the client could decide in advance when they sign the authorized representative form, I would like this person notified if I request a fair hearing.
Mhm.
Because not everyone, we do their vouchers. So we may not know that they requested a fair hearing, but we may know that they have dementia. And so, so there's something that they may want to, at the time when they are cognizant to sign over that release, they may want to say, if I ask for this, they know that they are, living with Alzheimer's, they may want to say, I where I want this person to know if I ask for a fair hearing. So, and the other piece, but that's the department. The department would need to know, could notify us. I mean, the Fair Hearing, the Human Services Board could too, but the department also could notify us, and we have a right to know what they ask for in their department. And then, so if I had called and said, did this person ask for a fair hearing, I would be able to have that answer. However, also, we would like that if someone is choosing someone to represent them and the Human Services Board is aware and the AAG is aware, the department is aware, that that person that's representing them be where the communication go through unless it's otherwise specified. Because when a client gets a call, they don't necessarily, when an individual gets a call, they don't necessarily know why they're getting the call. They might think it's about to get resolved right then. So if that so I don't know if that made sense.
Yes, I understand what you mean.
Okay. If the finding is in favor, after the hearing, a preliminary decision is made. And then the party who did not win the hearing has an opportunity to send that to the appeal to the whole board. So that came up and people asked, well, how does that go to the board? The party who did win does not have the opportunity to have it go to the board. And that's actually a recommendation that we have, is that it either automatically go to the board or those preliminary findings, if implemented, become part of the record. Because otherwise we continuously have to reinvent the wheel. And so we're often reaching out to legal aid or reaching out to disability rights and saying, do you have any cases of this nature that have already had a decision that we could refer to? And they can help us learn about it, but we can't actually find those cases. And so we really think that that's a big flaw in the system. And I will give a couple examples of that in a second. And then, because if the case is withdrawn, meaning that they follow the order, then that is also why I'm sorry, Representative Cole, that is why so many are you see as resolved ahead of time. Is because if the decision is made, then it's withdrawn, then it's officially withdrawn because it didn't go to the Human Services Board. So it's a little bit of a false marker. You might have already gone through the hearing. So I just talked about that. Now, people living with disabilities, the process for people living with disabilities is really challenging because, especially complex needs, because if they, for example, don't normally communicate with economic services, but have an authorized representative on their behalf, the clients are supposed to go through the fair hearing on their own. But sometimes the individual is someone who never does the communication for their voucher. So the authorized representative really is in every other circumstance is able to speak for them, but is not able to be a designee of the person to actually speak for them. And so we really do recommend that someone be able to designate a person on their behalf. And one example that we have of that is we have a client who is in a wheelchair and also has lives with a significant mental illness. And they have been not outside because our organization has paid for them, but because of reasonable accommodation, the department is not using its reasonable accommodation model. And we have won other fair hearings about this same issue, but he cannot go through a fair hearing. He presents like in a child-like way, and he will not be able to understand the process that's happening in front of him. And so because we cannot put him through that, we had our choices were let him be outside or let him pay for him. And we really don't have the resources to be paying for someone for as long as we now have, but we don't know what else to do. And now because of that, for example, in this executive order, he didn't qualify because we were not able to get him inside, but he has very severe complex needs.
Yes, this is only as an aside, but it sounded like a person who might qualify for developmental disability services. I don't know, but I mean, I would hope that you or somebody else on his behalf would be in contact with the designated agency to apply for developmental services if they have an intellectual or developmental disability.
Yeah, we have, and it's very challenging because some parts of his disability he's both thinks like that and processes emotion like that and is incredibly intelligent. And so some of that is very frustrating to him. And so we've had some challenges getting him through that process, but we've been working on it. We are working closely with the organization in his area on that.
And yeah, go ahead.
You've outlined a couple of shortcomings of for those who are trying to serve as an authorized representative.
Mhm.
Are there specific rules or anything set up as to what an authorized representative can do or gain access to, or what role they can play?
I'll include when I send this in the authorized representative form, but it is very, it's all inclusive. You have access to anything in there, cat and notes or any, and you can do any processes in economic services on their behalf.
It's essentially, it sounds like essentially a release of information.
It's a,
Authorization combined with an authorization to act. And
yes.
it's interesting. I mean, I think it does present a certain dilemma because as we heard last week, they do operate the Human Services Board in this kind of quasi judicial way. And so I think that we need to have some consistency in whether and how whatever written authorization is made is recognized by the board or the hearing officer. And there may be, we have somebody coming in after you from the Human Services Board. So we may be able to ask them under what circumstances, because it sounds like that it's different. And so in some cases, for some reason that I don't really understand right now, that they accept it as authorization, other times they don't. And I'm not really sure what the distinction is.
Seems like it's both broad and limiting.
I think it's always accepted, but it's if the person were to say, I don't want that person here, I don't want that person to know this, then they could, with the Human Services Board could say, okay, this person has said that they don't want. But otherwise, but within the department, I can always ask. But then the Human Services Board, and if I let people know that I'm representing them, I do think they check and make sure, but you can't always, like with some of our clients, you can't actually check and make sure. And we are able to speak for them, so we can say.
So I guess I'm a little confused because I might have totally misunderstood you. I thought you said earlier in your testimony that they don't always accept you as an authorized representative or whomever.
No, they do always accept us as an authorized representative or to represent them. They don't always notify us that it's happening.
Okay.
And so and it's not true that every authorized representative would be someone that would necessarily want to be notified. So I understand that, but it would be an easy shift to the form to ask that question when somebody designates you.
Okay.
So that's probably a change in the department. But the other thing that could happen is I asked at one point, is there a release that we could get for the Human Services Board that we could automatically ask our clients if they'd like to sign to get to them so that they know when a hearing comes in from them that they do want us to be notified.
So, just one second. So, if one of your clients has signed an agent form or whatever it is that they call it, a DCF, how do they, trying to figure out how you know that the client has done that? Do you get a copy of the form?
Oh, well, we have it. So we have a form, and a lot of organizations do, that says, our form says Brenda Siegel or any representative at End Homelessness Vermont. And then it has an org at the bottom. And if it's an org, then anyone at that organization can speak on their behalf. And then they can check that they are wanting this to be not just a limited, and there's other options for them. So we know because we hand it in.
Okay, so have you modified the department's form, or you use the department's form?
Use the department's form.
Okay, so you assisted them in filling that out, so you know it exists.
I know it exists, yes. Oh, yeah. but I know what's on it.
Okay, 100% care phone.
So just a quick analogy, and again, I just want to clarify. So you're saying that the authorization, when it's filed,
Mhm.
then everybody knows and everybody respects it. But the piece that may not be happening is that if there's going to be a hearing, then you may not be notified when you are the authorized agent. Is that correct?
Correct.
That's not consistently happening.
Well, and it happens if, for example, if sometimes it happens if our client is someone who we normally do their voucher and they happen to call in and do it, then we would be notified by Economic Services, this client asked for a fair hearing, by the way. And sometimes they're asking for it about something that's definitely not fair hearing material. And so then we're able to correct it there too. But if it's someone who we don't do their voucher, but we guide them through the process each month, because there's a lot of people like in that case, then we don't necessarily know that they have.
For those people, are you their authorized
Mhm.
agent?
Yes.
He's like, I'm an authorized agent for Medicaid for someone, and I get everything they get.
Yes. So
I literally get everything that gets mailed to them, gets mailed to me as well. So I always know what's happening. So in this case, that's not happening. It's only
right.
for, okay.
And we do think it should, because it would give people much more opportunity. And they're saying this person can know anything about my case. I can talk to the department and the department can tell me anything. So,
Thank you.
so another problem with people who live with disability is that people often and they're like asking for reasonable accommodation or, and maybe that those guidelines aren't being followed, as I've noted before, then, they are forced to demonstrate beyond what is required usually for a reasonable accommodation about their disability, and they're questioned about it in a way that is extremely uncomfortable and insensitive often for people who are in that position. So I can imagine in the situation that Representative McQuon talked about with a family, that would be very harmful. And we see that with our clients. And one example of that is a client that I did, I've now done 2 fair hearings about the exact same thing for, that he needed a reasonable accommodation. The department has specific rules about how reasonable accommodations will be met in terms of GA, and those rules are not followed in terms of how they find a room for someone who needs that accommodation. And so the first one was in the first hearing, we spent the entire time really getting attacked. He had a doctor's note, so he had documentation of his disability, of multiple organ failure and several other things, and on oxygen. And he also, he was outside, so his oxygen was falling to sometimes as low as below 50 briefly, and then he would pass out. He was very confused at that time. And he was having to answer all these questions that he really was struggling to answer because he was confused, plus he was running out of air, literally. And the questioning was very harsh. It was very hard for him to get through it. And luckily he had a representative and I was able to, object vigorously as these were getting more and more aggressive. But in another case, similarly, we had a client with a traumatic brain injury who would get very, very overwhelmed easily. And she said that in the beginning of her hearing. And she it was very, very aggressive, the questioning. And I was I was going to say that hearing officer Reinhardt, as he walked in on cue, was the hearing officer, and he was very, very good. Thank you. About in terms of when I objected in asking for the tone to change for the AAG's questioning and to give us a break so that I could talk to her about whether or not she could continue right then in her questioning. And also often gives me the opportunity to have a client only come on when they testify, which is not the case necessarily with all hearing officers. So it does change depending on the hearing officer. So that is something that I don't know why that's inconsistent, but it is. And when we're working with a client with significant disabilities around cognition or dementia or have severe medical conditions or mental illness, it complicates the issue because they may not be able to effectively understand or communicate the details of their situation, and they may also need support when being asked to communicate. But communication help is, to my understanding, is more for, and I'm not sure if I'm correct, but is more for people who have like are hard deaf and hard of hearing. Is that, or I don't know. So I'm not going to ask them that decide. I may be wrong.
Appropriate to ask.
Yeah, sorry.
That's right.
But in our clients, who, like I said before, who don't communicate with the department, it's hard to ask them to then communicate all of this themselves. They don't even often have the ins and outs and details of what we went through in the process.
And Brenda, do you find a consistent interpretation, I guess I would say, between the department and the Human Services Board in terms of what reasonable accommodation even means?
No, I would say that how much time do we have? But I would say that the Human Services Board of definition of reasonable accommodation is much closer to what the law is around the ADA and around what a reasonable accommodation is supposed to be. And the department's is very restrictive, especially around the hotels. It seems to only exist in wheelchairs. And that's what happened with the one example I gave of the person on oxygen, is that unless they were in a wheelchair, they didn't need a reasonable accommodation. That was the only thing that they could imagine was a reasonable accommodation need. And we have multiple emails back and forth where that's what's told to us when we ask for a reasonable accommodation for someone with a psychiatric disability or a disability of another kind. And it does seem like there's a broad and deep misunderstanding of what the ADA allows in terms of a reasonable accommodation. And so when we do go to the Human Services Board for that, in the times that I have gone, we have prevailed on that issue. And because usually we only do that when we think that it really is something that will be successful.
Right, okay, thank you. That's helpful to understand. It seems as though that they're, I mean, it's not unknown, I guess, is what I would say, what reasonable accommodation means. The ADA is not something that was just passed yesterday. And, you know, we've been having that legal framework for decades now. And so that's helpful and appreciative to know that the Human Services Board is more in line with, in your experience at least, is more in line with what reasonable accommodation means. Okay, thank you. Sorry for keep interrupting.
No, I'm glad because my ability to really prepare was limited. Another place that, and one more thing about reasonable accommodation, which is that we do understand that that there is a broad, especially within the people in emergency housing, there's a broad level of need and not all accommodations can be met. But we're talking about when it is very challenging, for example, to find a hotel room. In this client's case, he had to have a kitchenette because he's awaiting a liver transplant. And so there's are hotels with kitchenettes, but they're few and far between. And in his district, which is where all his emergency providers were, and all his specialists were, he had all the hotels where kitchenettes were available were on the list of the house that didn't have any new households. So you had to get a reasonable accommodation by using one of those hotels, but it was necessary for his survival. There's another place which we find really frustrating, which is policy change. And when we said we feel like they should all go to the Human Services Board, I think we share that sentiment to the full board. We share that sentiment with legal aid because otherwise there's often, even when it goes to Human Service Board, there's often not a policy change in the department. But we can't even refer backwards when it's a preliminary order. And so
What do you mean when you say they should all go to the Human Services Board?
we either think they should all go to the Human Services Board or they should become some part of the record that we can refer back to when someone else is doing a hearing. Because right now, like as I was saying in the beginning, that if it doesn't go, then I can't go find someone's preliminary finding. So I can't go find another reasonable accommodation finding that legal aid did. And so I now know that there has been a decision just like this, and I don't have to reinvent the wheel.
So let me ask another question. So, so my other experience is, with a system that actually documents the different levels of appeal that somebody might take advantage of. So at the local level, at the state level, and then at the Human Services Board level. And, are you saying that that doesn't happen in cases that you're familiar with, so that things that may get resolved at a lower level and through, I guess maybe, what seems to be less formal, but is still an official appeal. There is not a record of that.
Yeah, there's no record if it gets resolved at the department level. There's not, except like within that client's history, there's no record if that I can find. I could find my own cases, but there's no record that I can find it, to my knowledge, if it's at the preliminary decision and then the department changes it. So we've gone through the whole hearing. There's been a preliminary decision ordered, but we didn't take it to the Human Services Board because the department didn't appeal the decision. So there's no way to get
A decision by the Human Services Board,
by the hearing officer.
by the hearing officer. So
Right.
it hadn't gotten to the Human Services Board,
Right,
next step.
right.
So that's what, the witness last week was talking about, that,
Yeah.
apparently some things get resolved at,
Right.
various stages of the process.
Yes.
So I'm not sure it'd be appropriate unless, there was some data system that people would have access other than through the client's own record. Because, it would be indicated in the client's record that there was some resolution.
Right, and not necessarily the decision isn't necessarily present in the note in their record, in their file. So sometimes I have to send the decision to the commissioner or to someone else, so that they notice it if it's in order for it to get implemented. But oftentimes it does get implemented, and we can't say, we would like this decision to go to the Human Services Board to be finalized. It likely wouldn't change much once it went to the Human Services Board, or maybe it would. Maybe they would say, we actually don't agree with this, but there's nothing we can do if it was in our favor.
And so that leads me to another question. So that, if there, in previous experience, what I have experienced is that if, for instance, there were sort of repeated, and I'm going to use reasonable accommodation as well, because that one seems to be fairly consistent. If there were multiple appeals that got to the level of a hearing with a hearing officer at the Human Services Board, and may have been resolved after that hearing upon the issuance of preliminary findings, then that would cause the department to look at the regulations and their policy to ensure, that they were in compliance with whatever federal law that there might be, or even their own regulations. And I'm just wondering if that's your experience, or it seems as though what I'm hearing you say is that sort of the same types of appeals keep happening. And yet there's not a change in the policy or the enactment of maybe what is already existing in policy.
Yes, and you're just taking me through this testimony. So the next on my list is, there's a couple of examples where policy changes that are really poignant that aren't. Well, we've already talked about the reasonable accommodation and disability example. We've had several hearings, and so has legal aid had several hearings where the reasonable accommodation was found in the favor of the client and the individual that met their reasonable accommodation. Still, the department has not started to follow their own policy on this. However, another example that is constructive eviction. And in constructive eviction, there has been decisions in, I'm going to try to remember 2003, I believe, 2013, and 2000, and then another one more recent And then we had one in 2023 that all said that the person that informal living situations count for constructive eviction. They're all very clear. And so we're talking about 20 years of precedent, and the department has not changed its policy. And so we think that there has to be some requirement that the department change, just like if there was it's much a proceeding, as you heard, that can go to the Supreme Court that has to follow all of these, all of the measures of a court. But when there's a decision made that's a policy decision, like constructive eviction, and oftentimes quotes the previous decisions if they went to the Human Services Board, and that be implemented. Because that is just for the number of people who are harmed by actually having by having it not seen that way and not knowing that they can go to the Human Services Board to argue that. That's just not fair to people who are receiving benefits. And this is maybe unique, but a problem that we have had is that we have been representing someone as an advocate, and the department or AAG has come after us, come after me, and that the hearing officer did eventually stop it in that case, but it was really uncomfortable for the client. And I think that there has to be some better guardrails for that, because if someone is representing you our response was, we can call someone from our organization to testify, but I am not a witness in this case, so I cannot testify. And the hearing officer ultimately agreed. However, the client was incredibly uncomfortable with sending me text messages saying that he was worried because of the way that I was being attacked, is the only way for me to say it. And it made him very, very uncomfortable. And so I think that that's something that I hope is unique. It isn't happening all over the place, but is unfortunate if it is.
So in the situation that you're speaking of, you were acting as your client's agent?
Yeah, so but I was,
As their
no.
representative?
I was representing them in the fair hearing. So when you're representing someone in the fair hearing, you're the one questioning, oftentimes, you're the one questioning the other witnesses, you're having the communication back and forth within the hearing, not,
Right.
yeah.
The reason I'm asking is because if you were acting on the person's behalf, and you were essentially being the voice for that person and asking the questions and representing their situation, then what the assistant AG should be treating you as though you were the client.
Right. So no, not in this case, especially in these cases, this particular one, the client was there to testify on his own behalf. I'm asking the questions. I'm representing him, much like I'm not acting as an attorney, to be clear, for all legal purposes, but it is much like the attorney would be representing them. So I'm making a case, not
used.
okay.
If a client signs one of those, releases, one of those authorizations, in the situation, and so they can be present or not present, and still sign one of those things authorizing an agent or an individual to act on their behalf, then, and that doesn't mean that they can't speak, or communicate at a hearing. But it does, I guess in my head, it does say, okay, this person is authorized to speak on behalf of their client. And that means that they, in my way of thinking, should be treated as though, you should be treated with the same respect that the client should be treated with, because you're acting on their behalf. I guess that's the way I'm trying to get at.
I would probably go to, we should be treated with the same respect that and without that the attorney would be, because we aren't allowed to testify. So if I'm representing them, I can't testify. I guess I could call myself as a witness, but I can't testify and actually speak for them. I can ask questions. So I can't put testimony on the record.
Right, I understand. what-
So it's a little bit different
Yeah,
than that. When I'm working with the department, I am actually acting on their behalf. So it's just a slightly different thing. So it'd be good, I mean, that, yeah.
well, I think there's a difference between an individual organization being an advocate for a person.
Yeah.
And being there if I were asking Ann to be my advocate, which I would, 100% do.
Me too.
If I were asking Ann to be my advocate, I'm there to support her in providing my own story, okay? If you're their representative, to me, that's a different thing. That means that you now are representing my story. And I may still be there, but I've authorized you to represent my story. And if you're an advocate, you're there essentially kind of for the moral support and maybe consultation if I needed something. So I wonder if it gets confusing
Mhm.
when you're there, not you, but when anybody is
Yeah.
there as an advocate versus really representing the individual.
I think that it is different than morals. There are people who come and provide moral support, and then there are people who choose someone to basically argue their case, but they're still not their witness for them. And so for example, in this case, you couldn't come after my credibility because I wasn't actually providing testimony. I was just asking the questions. And so I went and making the case. And so there was nothing really that what I was presenting for the record that was a question of credibility or anything else. But the witness himself was providing those type of things. And so there was a clear line there. If somebody's coming just as moral support, it operates differently because the person themselves is presenting the case.
I just think that we have to sort of keep in mind when we're thinking about potential changes, that there's a different role between representing an individual, whether you're a lawyer or you're sort of a person has authorized you to represent them versus an advocate, or support person who is, there just to do that essentially.
Right, I agree. And
Go ahead, Representative Bishop.
Does it get more challenging in your circumstance in that there may be evidence, discussion, et cetera, relating to information, for example, that your organization may have provided the department, as opposed to me, Joe Citizen, helping my neighbor out?
no, because we call someone else from our organization. So I don't answer those questions if I'm the one representing them. And I don't, and what's on the record is there, but if the client is testifying, we have already talked about what is on the record so that they are aware of that ahead of time. So they are able to provide that testimony. And when they asked to call me, I just automatically offered to call our staff instead. So there was a way around it. I don't think there did used to be for us because it was me a lot. So, and doing everything. Now I have amazing staff. So, and then there's a few things that came up in questions that I had some answers to. And you're going to hear, I'm sure, can the Human Services Board decide against the department rule? I'm just, in my experience, they can decide that the rule is in conflict with the law. And we have argued that point before. And that I understand that that's in the rule or that's in the interpretation of the rule, but the statute says this. And so we have utilized that before. And they can decide that the department's interpretation of the rules, because if you've ever looked at the rules, there's rules and there's interpretations of the rules, and that the department's interpretation of the rule or statute is not correct. Both of those things have been decisions that we have experienced before. they can decide that a request for reasonable accommodation is allowed under the law. So those are things that are available, even if the rule is in somewhat conflict of that. We talked about why cases are sometimes dropped. And there was a question about entity under contract with AHS and should that be added? And we do recommend that due to H91 that be added and that there, so that there's a clear path. Where appeals only happen within an organization, that creates an inherent conflict in our opinion, because there is no neutral party involved in the internal appeals. So that is really hard on clients. They don't know, they can't feel like it was an objective experience. And there was a question about how long it takes to get discovery. It's gotten better, I'm going to say. We had a whole meeting about it where Legal Aid and Homelessness Vermont and the department was present. And we talked about the discovery issue. We do often, though, still get discovery when they're expedited hearings the night before the hearing. And that is just not enough time to review or the information or defend any negative information or find any defense for the negative information. It's also confusing why some of it takes so long because it mostly consists of Catton notes. Those are the notes that the ESD client file is called Catton notes about the emergency housing and vouchers, which are all right there. So we would recommend that it is standard discovery, such as Catton notes and things that can be immediately available are delivered to the person who requests the hearing pretty immediately within 24 to 48 hours, because it literally is a direct pull from their own notes. We understand that additional discovery might take more time, but having to read the whole file the night before is very, very challenging. And there was another question about can people withdraw and then reappeal? And people can withdraw and then still appeal their case. I believe that they have about 90 days to do so within the department rules. So I'm not sure about that. And there was a question about the experience for individuals. And we've talked about this a little bit, but it's not great for households. They go into it kind of thinking that it's not a formal proceeding. And in some ways it can be more compassionate, again, depending on the hearing officer. But it also depends on the AAG. And sometimes the AAG is quite aggressive. And that is really a terrible experience because the person feels like they're being treated like a criminal when they're not. And so whether or not that's the intent, that is the feeling, that is the result. That experience for me has been the worst part of the hearing for the client in what we've seen. And you heard that example of our client with a TBI, and there are other examples I could give, but I will not. But we did have another client with a TBI who couldn't understand that there was no flexibility in the 80-day limit. Her brain could not process the information, so she thought was delivered by the department. As I said before, and in this instance, she was able to get her story fully out. In another example that you heard about before, the person felt like there was so much attack that they really didn't have time. And so that was a much different feeling, and it was also a different hearing officer. So I do think that it matters the difference, and it was also a different AAG.
Question, go ahead.
Is there a specific amount of time allotted for each hearing, or is it like whatever is needed?
Well,
Is that inconsistent?
It's usually they're supposed to be shorter, but they often go longer. And if they go longer, they do give more time for them, just like a court often does. And so we have had in this one complicated case with the person on oxygen, the first emergency and preliminary hearing, we had a preliminary hearing for that one and we had 3 hour-and-a-half hearings to get to the result that he did need a reasonable accommodation. And the second time we also had 2 hour-and-a-half hearings. So that was very, very complicated, but or that we might find that there's more evidence that's needed, or sometimes a witness doesn't show. And so there's often time given on both sides to alleviate that. And then I understand, So in this one case with the dietary restriction, I want to just add that the hearing officer literally had to shout over the AAG to stop them from asking aggressive dietary questions. And that is something that I had not ever experienced before. And so that to me seemed unacceptable, unprofessional, and unreasonable. I have never experienced that. I've usually experienced, even if it goes a little too far, the AAG or the department walking that back a little bit in understanding that it's a human being. And I completely understand the need to cover all the bases because it can go to the Supreme Court. However, it's not a criminal proceeding. Like family court is not a criminal proceeding. And I think there has to be some clear restriction or some clear guardrails, Jersey barriers, as I called them when I was a teacher, around where you can play within this, but you cannot cross the Jersey barrier. And I do feel that it has to be a little more, and it often is, but it's not clear.
I'm gonna ask the previous witness, Mr. Reiner. Does the Human Services Board issue guidance to witnesses like the AAG and the, clients who come or people who represent them? I mean, I saw your document before, but I'm just trying to understand if you are experiencing, you or any of the other hearing officers are experiencing, what might feel to an individual who's not accustomed to that kind of situation, might feel like they're sort of under personal attack. Is there any kind of feedback that maybe you provide to other than in the moment trying to stop the situation, but is there any kind of feedback that you provide to the assistant AGs, like after the fact, or trying to encourage them to maybe present their side of the story in a way that seems more respectful to the person who is appealing?
I would say generally not after the fact. I think it happens in the
Kind of in the moment.
Yeah.
Yeah.
We do usually, and especially if it's going to be longer testimony or more involved, I'll give the witness some information about the process. Not so much feedback with the AAG unless we're asked about it in an evaluation process.
Yeah. Yeah. Yeah, go ahead. Yeah, go ahead.
I'm sorry.
Yeah. That's okay.
Just either one of you. So the state does have a performance office that is, their goal is to kind of improve processes statewide and like key inefficiencies and make experiences better. I'm just curious if either of you are aware of them. Has there been any, because they actually come out and like process map these big complex processes and figure out where the pain points are. So I'm just curious, are you aware of them?
I'm not.
Okay.
Interested to hear about it.
No, yeah. And I do want to say that I have made a complaint about and had a significant conversation with hearing officer Reiner about what it feels like for people with disabilities. And not a formal complaint, but I did say I'm really concerned about and this was in the beginning of when I started doing it. And we did have an at-length conversation about that. And I have brought it up as well when we were in our large meeting with legal aid. And I do think that there is a need to just level set that we're talking about a human being just trying to get a benefit, not a human being that's done anything wrong.
Mhm.
Usually, almost always.
Mhm.
So that's, the answer may be no, but especially with the clients that we're working with, it could be an answer. The no answer could mean that they will not survive. And so that's a pretty challenging no, and probably hard on the officer as well. And I just hope that we have an incredibly compassionate process for understanding. And that's true with healthcare. That's true with, and anything.
It seems like you're at the end of your testimony. Is that?
I am.
Right. Okay, well, that timing is good.
I made it this time.
Thank you. No, thank you. And thank you for allowing us to interrupt and ask questions along the
Sure.
way. and appreciate, we want to make these efforts better, both for the people who are, in the middle of the process, who have to carry out the process, as well as people who feel like they need to experience the process because of an issue that, that they feel is in their best interest to appeal. So I very much appreciate that. Thank you very much, Brenda.
Thank you.
And Lori, I'm just wondering if Michael Donahue is going to be in person or he's going to be on Zoom. Okay. He's not here yet. Okay. Okay, so